Welcome back to the Making International in Korea video series. In this video, I'll be explaining to you about important subject and object of international law, which is the state. Because the international system today does not have a world government, state creates the rules for themselves that are applied to and enforced against them. In such a horizontal system, the state is most vital entity in international law. If you look at this slide, you may find a very interesting the photos. The first photos about the Rose Island. It was the movie that appeared in Netflix about very interesting case in Europe. One of the young men builds the infrastructure outside the territorial sea of the Italy, and they want to declare that as a state. And that case go to the European Parliament and cause the international tensions and regional tensions in Europe. And that case is taped as a movie was the Rose Island. You can see that the exact features of the Rose Island in this regard. The prevailing view of statehood is that the modern state arose from the settlement created in the political legal arrangement that was produced in resolving the 30-year war. It spurred on the conditions for a new world order that would eventually be based on the principles of the territorial sovereignty. As Malcolm Sherry is a very famous international lawyer in UK, note, this order involved the recognition of the all independent states as having equal rights of the sovereign jurisdiction over determined territory. This sovereign equality of state was founded upon the exclusivity of action of each state within its defined territory and the right of the all states to participate within the sphere of international relations. As you will find, the key terms from here is the territory and the actions, the exclusivity in that defined territory and the right of the all states to participate in the sphere of the international relations. Therefore, whereas the pre-Westphalian order conceived of this jurisdiction over persons and subjects allowing for multiple authorities, for example, the local prince or elector or church or the empire, to exercise political or legal power within the same geographical space. The Peace of the Westphalia signaled a swift toward jurisdictional exclusivity of the one sovereign over a defined territory. The strict requirements of a defined territory as an essential element of statehood was not immediately established after 30-year war. As the transition to a truly international system for relations between independent territorial states involved a lengthy process. Indeed, the aftermath of the war did not see formal demise of the Holy Roman Empire until August 1806, nor did the papacy lose authority over those persons and places that pledged their allegiance to the Roman Catholic faith. Given the continuing, albeit weakened, authority of the empire, the presence of the Roman Catholic Church and territorial actors presented a practical problem as to how to recognize and engage these new territorial entities. It was at this time that Gottfried Wilhelm Leibniz, the German philosopher who is commonly known for his work in mathematics, developed a pragmatic yet normative understanding how authorities old and new could interact with each other. Coining term of the international legal personality, he proposed the engagement of the various post-Westphalian rulers on a basis of relative sovereignty, whereby even if the ruler did not have jurisdiction on some matters within his domain, he could possess international legal personality if he had the rights of territorial hegemony and a large territory. From Leibniz's perspective, territory was an essential element to establish some measure of international legal personality for entities today that would not be considered as sovereign states. The notion of international legal personality itself has undergone changes as it became identified with statehood in the late 19th and early 20th centuries. The association of the particular territory as a requirement for statehood would also come around the same time. Unanimity prevails that territoriality is a defining attribute of the Westphalian states, and it is probably even correct to assume that a territory owner constitutes the most distinctive feature of traditional international law. Let me move to the nature of states. According to Hans Kelsen, the famous European philosopher and international lawyers and political scientists, the traditional international doctrine distinguishes three elements of state: its territory, its people, and its power exercised by independent, effective government. It is assumed to be of the essence of state that it occupies a certain limited territory. The requirement to territory has been consistent among various commentators since the 19th century. The 1933 the Montevideo Convention on Rights and Duties of States, which now reflect the customary international law, provide a legal, less theoretical definition of state and statehood: a permanent population, a defined territory, a government, and the capacity to enter into international relations. In contrast with the previous versions, the capacity to enter into international relations is added and to be noted more carefully. These elements of statehood represent objective requisite of statehood. Despite changes in this element, the state persists. The Rothbard, a very famous international lawyer in his generation in UK, writes, "A state remains one and the same international persons in spite of changes in its headship, in its dynasty, in its form, in its rank and title, and in its territory. No states lacking these elements can exist in perpetuity, but states may temporarily lose one or more of these elements entirely or yet survive in limbo." As you may see that the climate change hit the Pacific Ocean, many small islands there will lose their territory soon. There is a serious talk in international community. What is the statehood of those small islands will lose their territory in the future? And at the same time, if some state who has some lacking of the power to maintain or enter into international relations, for example, Taiwan is a state or not, we'll get back to the issue a little bit later on. The state may repeatedly suffer fluctuations in its population, territory, or the government, and yet return to equilibrium. This return, however, presumes the non-destructive fluctuations in the system, for any destructive changes vitiate the system. To discover if a certain entity is a state for international purpose, it is not enough simply to ascertain empirically whether the state has an effective government that represents to the world a defined people in a delimited territory. That inquiry is both under-inclusive and over-inclusive. It is under-inclusive because it fails to ask whether the international community has conferred legal status on a putative state, and also it is over-inclusive because it fails to account for the bona fide states that have been deprived of one or more criteria of statehood. Thus, in examining the birth and death of a state, one's eyes must remain fixed on the state's legal personality and hence on international law. International, however, cannot fashion a state from its own clothes. A state must possess the necessary preconditions of statehood. You may say that the photos from this slide. This is a very famous feature in Korea, located between Korea and China. In Korea, we call this underneath feature as the 이어도. In international law, known this 이어도 as a Socotra rock, and there is an infrastructure over there. And if you compare with the first slide of this lecture and say that the Rose Island, and if somebody goes that the Eodo Station claim as Eodo Station or Eodo States, can you call that Eodo can be categorized as a state or not? This is a very interesting question when you refer to the statehood in international law. Thank you.